During a Senate Agriculture Committee hearing on Thursday, Senator Debbie Stabenow questioned Commodity Futures Trading Commission Chairman Rostin Behnam about the collapse of cryptocurrency exchange FTX. During his testimony, Behnam claimed that FTX and Sam Bankman-Fried met with CFTC officials about 10 times in the past 14 months. The numerous meetings came as Bankman-Fried tried hard to amend LedgerX's clearinghouse license, an entity that is owned by FTX and is registered by the CFTC. This hearing comes after Sam Bankman-Fried gave an hour-long tell-all interview at the New York Times DealBook Summit last week. Against his lawyer's advice to stay quiet, Bankman-Fried defended himself, claiming he never intended to defraud consumers, but did admit that he, quote, screwed up.
Thank you very much, Mr. Chairman. And we will have 7-minute rounds because of the importance of this issue and having our one witness today. Chairman, you testified that CFTC has a limited window into FTX operation, apart from the one entity that you talked about, LedgerX, which is registered with the CFTC. Based on the visibility that you have into LedgerX and the information that you learned from discussions with other regulators or FTX, what can you tell us about the cause of the FTX collapse?
Thank you, Senator, for the question. I'd say at the beginning very clearly the LedgerX relationship was essentially walled off from other affiliates and other entities in the FTX family. So we had a lens into FTX, and as I've stated and as you've recognized, the entity is healthy, it's solvent, it's operational, and we know where customer money is. But the limitations of our authority stopped at that entity. And the sort of reciprocal relationship is, for those same reasons that we were walled off from going past the regulated entity, the other FTX entities were not able to pierce through LedgerX and potentially take customer money, which obviously as a regulator, that is the priority. In terms of what happened and what we're learning, obviously a lot of information continues to come in. But as we look at what we've learned thus far, it seems like a classic liquidity crunch that really forced a run on the institution. Over a series of days, there were concerns about the health of the FTX entity and all of the affiliates. And at that point, as we've learned, a number of the customers and investors started to withdraw their funds, which really cascaded into a massive withdrawal of funds, which at some point, FTX had to stop those withdrawals and then ultimately file for bankruptcy. A lot of indications about commingling and not using custody to protect customer property and a series of conflicts of interest, which you also pointed out. So these are the things that we've learned so far, but continue to monitor the situation. But ultimately, it looks like a classic run based on a liquidity crunch.
Thank you. FTX had requested that CFTC amend LedgerX's clearinghouse license, and the agency was reviewing that proposal at the time of their bankruptcy. Could you please describe for the committee the agency's interactions with FTX and its former CEO regarding this request, as well as the status of the request before it was withdrawn?
Thanks, Senator. I'll try to be as concise and comprehensive as possible. It's an important question. We had, and FTX was dogged in their pursuit of getting an approval for this application for the clearinghouse. But certainly, as I can't speak to the number of meetings necessarily that Mr. Bankman-Fried and his team had with staff. I do know they were in the building quite a bit, talking with staff about the details of the application. I can, though, share with this committee with respect to me, my team and I have taken an initial review of my calendar, and what we've observed is that my team and I met with Mr. Bankman-Fried and his team. Over the past 14 months, we met 10 times in the CFTC office at their request, all in relation to this DCO, this clearinghouse application. 9 out of the 10 times we were in Washington, one was at a widely held conference in Florida earlier this year. In addition, there were 2 phone calls, I believe, and a number of messages, all in relation to the DCO application, providing us updates, suggesting that they were answering questions from different divisions, and trying, as I said, to doggedly move the application along and to get it approved. I would say it's really important to understand that by law, by statute, we needed to address and respond to the application. We did not have flexibility to put it on the side of the desk or disregard it. We had to respond to it. And knowing the importance of the issue and the very strong feelings on both sides of the application, both in support and opposition, I made a decision very early to be as transparent as possible with the process. So in March of this year, we put out a request for information, a series of questions to the public trying to get as much stakeholder input. We received 1,500 responses to that request for information. In May of this year, we had a public roundtable on non-intermediation, specifically on non-intermediation and not the FTX application, because this application was not the first of its kind, and I will tell this committee it's not going to be the last of its kind either. This will continue to be an issue for the CFTC. All that said, this application had the potential impact far beyond FTX itself. It had the potential impact across market structure, across derivatives markets, and potentially across all financial markets. And it was for that reason that I decided, me as chairman, to be personally engaged as much as possible. There were very, very strong feelings about this application, and I felt I needed to be engaged as the chairman of the agency. That meant directly with FTX and Mr. Bankman-Fried, but that meant with other CEOs of public interest groups, of clearinghouses, of exchanges, of academics and regulators as well. And in many respects, this is consistent with what I've done in the past, but it is also consistent with recognizing the importance of the issue. I want to be responsive to stakeholders, I want to be respectful to stakeholders, and I want to have an open door policy so that my team and I can learn as much as possible. With regard to the last question, and I know there's been a number of reporting lately about the status of the application and where it was. The application was applied or submitted in December of last year. As of the withdrawal date, which was, I believe, November 11th of this year, there was no decision. There were more questions than answered. There was no decision or recommendation from staff. There was no pressure from any outside sources. As I said, we were doing what we were obligated to do by law. We were being very careful and surgical in examining the issue and including as many people and stakeholders as possible to better inform our decision.
Thank you very much. And last question before turning to my colleagues. Would the conduct that led to FTX failure have been prohibited under the Digital Commodities Consumer Protection Act? If you could speak briefly.
Sure, Senator. Based on what we know thus far, a lot of the issues that have arisen and sort of come to light is significant conflicts of interest, significant allegations of commingling customer money and house money, lack of books and records, lack of corporate governance and risk controls, just to name a few. And these are, from our understanding and working with you on the DCCPA, core elements of the DCCPA. So I certainly think, given the events of the recent past, we should take a fresh look, but the DCCPA does address these issues and would have prohibited those actions from occurring at FTX.
Thank you.